this is Lavanya from Lexis and Company, working as an intern. Today I'll be talking about summary judgments under Commercial Codes Act. The purpose of the summary judgment is to avoid unnecessary trials. It may also simplify trial when partial summary judgment dispenses with certain issues or claims. There are two criteria that must be met. First, there must be no genuine issue of material fact and the movement must be entitled to a judgment as the matter of right. Order 13A states, wherein the order is passed without recording oral evidence, the claim is decided in the absence of it. Application of summary judgment is given at a time after the summons is served to the defendant. However, the application cannot be made after the issues are framed by the court. It can be granted on the following grounds set under Order 13A Rule 3. The plaintiff has no real prospect of succeeding on the claim, or the defendant has no real prospect of successfully defending the claim, as the case may be. There are few instances where the court has not allowed the application. One such case is Rockwool International AS versus Thermacore Rockwool India Private Limited, where triable issues were found in which the mark alleged to have been infringed was a valid registered trademark and was generic in nature. In this case, court was also of the opinion that it can take so moto cognizance in passing the summary judgment. Second, there is no other compelling reason why the claim should not be disposed or before recording of the oral evidence. The court can pass such orders as the judgment on the claim, conditional order in accordance to Rule 7, dismissing the application, dismissing part of the claim, and a judgment on part of the claim which is not dismissed, striking or pleadings. Further directions to proceed for the case management under Order 15. For the procedure of summary judgment, the court shall, in addition to any other matters the applicant may deem relevant, include the matters set forth in clauses A to F mentioned. The application must contain a statement that it is an application for summary judgment. The application must precisely disclose all the material facts and identify the law points. The application must state the reason why there is no real prospect of succeeding on the claim or defending the claim. The application must state what relief the applicant is seeking and briefly state the grounds for seeking such relief. Where the hearing of the summary judgment is fixed, the respondent must be given at least 30 days of notice. The respondent may within these 30 days of notice of the application of the hearing file a reply addressing the matters set forth mentioned under. The reply must precisely disclose all the relevant facts, idea of the law point, and reply must state the reason where there is no real prospects for it. Now, evidence in summary judgments. Filing of the documentary evidence and serving of the copies of these documentary evidence to the other party. Orders that are made by the court are the judgment on the claims, striking the pleadings, and etc. In conclusion, summary judgments are the mechanisms to determine an issue before the trial court support one of the key principles of the rules of CrPC, and the procedure is set forth with the sole purpose to reduce the time period in deciding the commercial disputes of specified value and to ensure fairness and transparency in effective justice and delivery.